Welcome to our latest Employment and Immigration webinar. I'm Devan Khagram, a partner in the employment team in London, and I'll be chairing today's session. I have to say, I certainly never imagined a year ago when the Prime Minister first asked us to work from home, that a year later we'd still be here working from home and in this scenario. Of course, earlier this week, there's clearly a roadmap to some better news, but I guess the one positive thing that's come out of all this is that instead of having these in-person seminars, the webinars have allowed us to reach many people who, would not have ordinarily come to our webinars. So I'd like to welcome all of you today. We've got a really good turnout, so that's good to see. Of course, COVID has had a massive impact from an employment law perspective, and employers have been facing challenges that they've never had to, some of them never had to face before, or it's certainly brought certain things to the fore. Furlough has come to the fore, which is a brand new concept. Employers have had to think about reduced working and redundancies, etc., etc. And today, of course, we will tackle some COVID-related employment issues. For example, Anna's going to talk about working from home abroad, which has become increasingly prevalent at this time. But there's also several non-COVID developments which we didn't want to go by the wayside, and we'll be covering topics. Elena, who's a consultant on our team, will be talking about the IR35 changes. I'll be discussing positive action. Elliott, our resident immigration expert, will be talking about the post-Brexit immigration system. But the plan is to kick off with Hannah Myers, an associate in our team, and Janet Simpson, our professional support lawyer, with them looking at significant cases and non-COVID developments in employment law. But before we kick off, I want to just cover a couple of housekeeping points. Firstly, please note that participant video and audio has been disabled to minimize disruptions. But if you'd like to ask a question, there's a Q&A tab at the bottom of your screen. Please feel free to put your questions in there, and the plan is at the end to gather the questions together and respond to those that we can. And of course, you can email the speakers directly after the event if there's something that you don't put on there or don't think of at the time. Please note the webinar is being recorded. And finally, I just want to say that to engage you as an audience, we've got a series of poll questions coming up. Please do participate. It'd be great to know what you all are doing as organizations. Your responses are anonymous. So on that note, we're actually going to kick off with a poll question before I hand over to Janet. So our first poll question is, has your company taken out cyber insurance to cover the costs of accidental or deliberate data breaches? Now, it may seem sort of a slightly random question, but it will be something that Janet and Hannah will cover, and it's becoming more prevalent. So please do answer yes or no on the screen. And I'm going to now hand over to Janet. Thank you.
Morning, everyone. I am going to talk first of all about a case on TUPE called Ferguson and Astra Asset Management Limited. By way of background, TUPE was introduced to protect the rights of employees when a company was sold, because traditionally, once a company was sold, the workers had no rights to transfer to the new owner. Now, in this case, the claimants were the directors and senior employees of a property asset management company. They said that they awarded themselves some very, very beneficial terms and conditions when it became obvious that their contract was going to be terminated. Now, what happened here was that the terms that were more beneficial were the fact that they were given a much longer notice period. They had a fantastic bonus, which was something like 50% of their salary, and they had a better termination payment. The transfer was covered by TUPE. Now, the information that was supplied to the incoming buyers or the transferee did not disclose these very beneficial terms, but they only disclosed it at the last minute. And when the new terms came to light upon the point of the transfer, they were dismissed by the transferee for gross misconduct. Now, the question was, were these beneficial changes valid post-transfer? Now, the idea of TUPE was to preserve the rights of employees once a transfer had taken place. Now, there had been a previous case called Power and Regent Security Services, which had implied that it was possible to have increased conditions of employment post-transfer. But in this case, they said no, that no variations to contracts which are by reason of the transfer can be valid. So the dismissal was upheld. They also said that the changes offended the EU abuse principle. And this is a rule which says that EU law cannot be used for fraudulent means. So on this basis, the changes were void and the abuse principle applied. And the EAT upheld both findings of the tribunal. So essentially, no changes can be made by reason of the transfer. The second case I want to look at is concerned with data protection, but it's also concerned with vicarious liability. The case was called Morrisons and various claimants. Now, a Morrisons employee had been disciplined and had taken upon himself to take a big grudge about this. And what he did was that he shared the personal data of almost 100,000 employees with members of the press and various websites. And the employees brought an action claiming that Morrisons was vicariously liable for the criminal acts of its employee. And all the way through the courts, all the courts had decided that yes, that was the case, that Morrisons were vicariously liable for the employee's unlawful actions. So the case went all the way to the Supreme Court, and the Supreme Court looked at the law regarding vicarious liability. A more recent case has said that where in the case of a petrol pump attendant who had assaulted a customer, that in that case, the company that owned the petrol station was not liable, because the test is whether or not the actions of the employee is acting in the ordinary course of their employment. So what the Supreme Court said in this case was that it was obvious that this man was not acting in the ordinary course of his employment. Vicarious liability was not established. And they went back to the well-known test of vicarious liability, which is that an employer is not liable if the employee is acting on a frolic of his own. Now, what are the implications of the Morrisons decision? So while the spectre of strict liability has fallen away, there is still a significant risk. It's the well-known fact that the poachers are always one step ahead of the gamekeepers. And the Information Commissioner has imposed some very substantial fines upon organisations for inadequate technical and security breaches. You're probably aware, excuse me, that British Airways were recently fined £20 million for a large data breach. So although, yes, the strict liability point has gone away, organisations have to make sure that the measures they are taking to protect data are appropriate and are the state of the art. I'm now going to hand over to Hannah Myers, who is going to talk about two significant decisions on unfair dismissal and discrimination.
Thank you very much, Janet. Morning, everyone. So this first case I'm going to talk about concerns unfair dismissal, and it's Gallagher against Abellio ScotRail. So this was a rare case where dismissal for loss of trust and confidence without any prior procedure having been followed was actually found to be fair. So in order to be fair, the manner of a dismissal must be within the band of reasonable responses to the facts faced by the employer. So Gallagher, who I'll refer to as G, and her line manager T, initially got on well, but the relationship soured when G asked T for a salary increase and did not get one. So G didn't hide the fact she was looking for a transfer away from T, and she didn't deny that the necessary working relationship between them had broken down. So to make things worse, G was quite senior, and her attitude to T was therefore harder to ignore. It was also a time of particular pressure and poor results for the business. And the tribunal did accept that T had quite legitimately had less time and patience to devote to this matter than might otherwise have been the case. So in May 2017, G attended what she thought was an appraisal, only to be told out of the blue that she was being dismissed and that she was not being offered any right of appeal. So a tribunal found the dismissal fair, and this was upheld by the Employment Appeal Tribunal. So essentially what they said was, following a procedure here would have served no useful purpose and might have even worsened the situation. But it was made very clear to any employers thinking of trying the same thing, that quote, it would be an unusual and rare case where an employer would be acting within the band of reasonable responses in dispensing with such procedure altogether. So such a case would require the employer to conclude reasonably that in those exceptional circumstances, the procedural steps which would normally be appropriate would have been futile. So these are extreme circumstances, and the hurdle is a very high one. But the EAT found that on these facts, Abellio had cleared it with some ease. So this next case, I'm going to talk about concerns discrimination, Taylor against Jaguar. So Taylor, who I'll refer to as T, was an engineer at Jaguar, and she'd been there almost 20 years. In 2017, she began identifying as gender fluid, non-binary. As a result, she suffered harassment and discrimination from her work colleagues in the form of comments referring to her as wearing a Halloween costume and asking her if she was going to get her, quote, bits chopped off. So plainly, such comments were incredibly offensive and unwanted and amounted to harassment. So T also suffered problems regarding the use of toilet facilities, and she received little to no support from her managers during this time whenever she raised complaints about the situation. There was also an incident in August where the claimant heard two colleagues talking about her. The first said, "Have you seen it?" And the other replied, "I saw it in the atrium." So when the claimant reported this to a member of the HR leadership team, that person responded by saying, "Well, what else would you want them to call you?" So the claimant ultimately resigned from her position at the company and issued claims in the tribunal of discrimination on the grounds of gender reassignment and constructive unfair dismissal. Essentially that she had had no choice but to resign due to the way she had been treated at work. Jaguar argued that because T was a gender fluid, non-binary person, her claim could not be successful as it did not fall under the protected characteristic of gender reassignment under Section 7 of the Act, which makes reference to a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. But the tribunal found that the claimant did indeed have the protected characteristic of gender reassignment, as regardless of how she described herself, she was on a journey of transition and did not need to have arrived at the end of the very broad spectrum. The tribunal went on to conclude that the claimant had been very badly mistreated by her work colleagues. It noted a lack of support towards the claimant when she raised complaints, and the judge also noted that surprise that the respondent tried to rely on the statutory defence, which is where the employer puts forward an argument that they've taken all reasonable steps to avoid the discrimination from occurring. And quite the contrary was the case here. Also to note, whilst the respondent did have an equal opportunities policy, it was unable to actually produce it until the end of the employment tribunal hearing, could not evidence that the staff were aware of it or had been trained on it. And this was of particular concern, considering they had around 50,000 staff, if you include agency and contractors. And the respondent was therefore one of the biggest employers in the West Midlands and had ample HR resource available to it. And the respondent in this case agreed to pay the claimant £180,000 in compensation. So I am now going to hand over to Devan, who's going to talk about positive action.
Thank you, Janet and Hannah, for that. And some of you may have seen that the results from the poll question that I asked pop up, but it was quite interesting to see that I think just over a third have taken out that insurance against the data breaches, the type of thing that Janet was talking about, and 2/3 haven't. And I expect that that figure is probably higher than it would have been a year or two ago, and it's probably going to increase in terms of that, because data, people working from home and moving about, I think the risk of data breaches and things such as that are probably greater than they've ever been. So yes, thank you to Janet and Hannah for their bit. I'm going to be talking now about positive action, and this is something that's come a little bit more to the fore again with the gender pay gap reporting, because that's really highlighted once again, particularly in larger organizations, the fact that employers now need to really address the shortage of women in senior roles in these top organizations. So employers are thinking more and more about what they can do to address this, and with the ethnicity pay gap reporting also on the agenda potentially, I expect that this will become more and more to the fore. So people are thinking about positive action and steps they can take to try and address this imbalance. So what is positive action? Well, positive action is defined as voluntary actions employers can take to address any imbalance of opportunity or disadvantage that an individual with a protected characteristic could face. And just as a reminder, the protected characteristics under the Equality Act that we're talking about here are race, gender, religion, age, sexuality, disability, marriage and civil partnership status, and pregnancy and maternity. They're the ones that are specifically protected. And there's often confusion around how positive action differs from positive discrimination, because positive discrimination is illegal. You can't, the UK does not currently allow it, whereas positive action is permissible. And so discrimination occurs when a candidate is given preferential treatment simply because of a protected characteristic, regardless of whether they are equally qualified or the most qualified for that job. So for example, setting quotas and saying that we want to recruit this many number from this disadvantaged group, regardless of their quality, that would not be permitted. It would be considered positive discrimination, which is not legal. So what is therefore positive action? How does that differ from positive discrimination? So firstly, to use positive action, an employer must reasonably believe that a protected characteristic or people from a protected characteristic or who have a protected characteristic suffer a disadvantage, or they are proportionately underrepresented in the workforce. This can't be just based on sort of gut instinct. Really, an employer should have evidence behind this. They should look at perhaps national surveys. Obviously they should understand the makeup of their own workforce and look at whether there is, disproportionate, lack of certain groups in senior positions or in any position actually within the organisation. So firstly, you have to establish that disadvantage is there or underrepresentation. Now, in this scenario, to enact positive action, an employer must always offer a job or a promotion to the most qualified candidate. And they can't obviously have that policy of just preferring someone from a disadvantaged group regardless of quality. So positive action, effectively, how it works is it's a tiebreaker. Where you've got two people who are of equal quality, you can then look at the person from that disadvantaged group and promote them or recruit them ahead of the other person. You're not compromising on the quality of the candidate, you're just using that as a tiebreaker to decide between the two. Of course, you may get a situation where you've got two people who are equally qualified, but they're from two different disadvantaged groups that you're trying to, areas where you're trying to address. And here, you should try and adopt an objective scoring system to try and address this. And this is difficult. The Equality and Human Rights Commission do recognize it, because they're seeing employers take action such as mentoring and targeting training to try and address the imbalances, but not so much this positive action and tiebreaker, because they don't feel it's clear enough, and they've asked the government to try and clarify this. And I'll talk in a minute about how that can actually go wrong and cause issues where you get this positive action incorrect. But before doing that, I want to talk about a third category. So we've talked about positive discrimination, which is not permissible, positive action, which can be used in a tiebreaker scenario. But the third scenario where certain groups can be, promoted ahead of others is where there's an occupational requirement. And this is different from positive action. So here, there could be instances where an employer can specify a particular characteristic for a role. So for example, it would be legal and appropriate to specify that only women can apply for a role in a women's refuge because of a particular specific requirement. And to meet this requirement of an occupational requirement, there's 3 tests. They must demonstrate as an employer a robust and demonstrable link between the requirement and the job. There must be a good business case or aim for holding that specific requirement, and holding the requirement must be proportionate and appropriate and necessary in the circumstances. So think about, are there other ways of achieving it? Are there other things that you can do as an employer? But if there is an actual need to favor a particular group for a particular type of job, that falls into the occupational requirement. So it's different from positive action. As I mentioned, positive action can go wrong. So going back to that, there's tiebreaker scenario. And that was demonstrated in the case of Furlong versus Chief Constable of Cheshire. Cheshire Police had a recruitment drive. There were 3 stages in their recruitment process. They had the application, everyone's suitability was checked, and then they held an assessment centre. And to pass in that assessment centre, you only had to get 50%. And as many as 127 candidates were held to be of equal merit and passed that 50% mark. Now, Mr. Furlong, who was white, male, and heterosexual, was not successful, despite there was evidence that he was a really strong candidate. And he claimed race, sex, and sexual orientation discrimination. And in this case, the tribunal found in his favour that the procedure by Cheshire Police was unlawful in this situation. That's because they could not agree to the fact that 127 candidates could be deemed to be equal, of equal quality or equally suitable for the job. They said it was simply too wide, and actually what it amounted to was Cheshire Police giving preferential treatment to certain candidates who have protected characteristics, and they were being treated more favourably. So what the tribunal found is there was a legitimate aim. They were trying to address imbalances, but their methods were not proportionate. And looking at this scenario, I think the sheer number was simply too high. And as an employer, perhaps they should have looked at raising the bar to maybe 75%, 80%, and narrowing down that pool, and perhaps looking at, more than just the assessment centre. There might be other qualities, such as qualifications, experience, etc. And I think in this scenario, having some sort of grid where you score people, and then if you're scoring people and they come up with very similar or the same score, then you can go to this positive action. But as I mentioned, it is quite tricky for an employer to prove that 2 people are of the same quality. So you do have to be careful when using this, but it is a tool available, and the Human Rights Commission are asking the government to try and clarify that a little bit more so that it's more possible to use this. Okay, thank you. So that's my section on positive action. I'm now going to hand over to Anna Robinson, who's going to be talking about the topic of working from home abroad. Thank you.
Thank you, Dev. So I want to start my section, if I may, with a little poll question, if we can have it on the screen. There we go. Have you had a significant number of employees asking to work overseas during lockdown, yes or no? Okay, do we have the answer to that? Okay, interesting. That's very high. 61% yes, 39% no. Okay, well that's good, because hopefully this topic will be useful to you then. And I must apologise, because we promised we wouldn't talk about COVID, and of course my topic, working from home and specifically working overseas, is undoubtedly linked with lockdown. It is the case, as Dev said at the beginning, huge percentage of employees have been at home now for the best part of a year, something none of us could have predicted. And it raises a number of really interesting employment law questions, which I want to run through quite briefly in the time we have, hopefully to give you some red flags so that you can go away and think about whether you need to address your policies and the like. So, there we go. Contractual issues, first of all. The interesting point about the employment contract is that you probably don't have provision for working from home in your standard template. There's probably just a reference to the place of work being the office address, perhaps with some flexibility around moving the office address. So that then begs the question what you need to do going forward. It might necessitate a variation to your contract if post-COVID, you would prefer employees to be back in the office at least for some of the week. And in some cases, particularly once I've flagged some of the issues I'm about to, you might not feel comfortable with employees working from home, and certainly not from overseas. So do think about whether or not you need to change that clause and or introduce a supplementary working from home policy. Because what you need to avoid is an implied right to working from home or from anywhere arising over time through custom and practice. And that's the danger, of course, if you don't have an express clause, the implied terms creep in. So have a think about that after the webinar and whether going forward, the contractual provisions need to change. So what are the issues then? Well, first of all, let's just have a think about tax. So if you have somebody working from overseas, and you may not know they're overseas, of course, you know, the percentage was quite high on that poll, but it's entirely possible that you have other members of staff working in a different country and you're not even aware of it, let alone given your consent. And the problem from a tax point of view is that if somebody's been overseas for a sufficiently long period of time and they've been working during that time, then they may be subject to social security contributions and income tax in that jurisdiction, which can also have consequences vis-a-vis PAYE in the UK. So certainly you need to know where people are so that you can keep a tab on that, and you may need to take appropriate advice. The more frightening prospect, I suppose, from the corporate perspective, is the possibility of corporation tax arising. And that can be the case if the employee in question is sufficiently senior to enter into contracts and make sufficiently important decisions on behalf of the UK employing entity, and they're doing so from their holiday home or second home abroad, because what that can arise to is a permanent establishment, in quotes, in that country, which may give rise to corporation tax in that country if you don't already have a presence there. So it's quite an interesting one, and for that reason, some of the banks in particular have told board members, senior members of staff, that they can't work from their homes in Tuscany or wherever, precisely because it exposes the business to significant financial risk. But I think the point is you do need to know where people are so you can assess that risk appropriately. Similarly then, employment law protection. Oh, struggling to get there we go. So this is a similar point really to the tax piece. If you have somebody working overseas in, say, France or the Netherlands, and they've been there for a year or longer, then remember that over time they will potentially acquire mandatory local law protections and rights. And it might be that those rights run in parallel with their UK protection. So you could end up with a situation where an employee brings a complaint or claim in an overseas jurisdiction that you're not familiar with. It might be that the country in question has significantly more employee-friendly protections than in the UK. And I'm thinking here about France in particular, but also the Netherlands. It's quite difficult in practice to dismiss a Dutch employee. There's a court process which needs to be followed. Redundancy payments could be an issue. And remember as well on the continent that collective bargaining agreements and the like are much more prevalent than they might be in the UK. So for that reason, again, you need to think about whether you're comfortable with that situation arising. And if you're not, you need to look again at your contracts, and at the very least, you need to know where people are and for how long. Immigration. So the point here is whether working overseas necessitates a visa. It used to be easy, of course, if we're talking about Europe because of free movement, but now that we're post-Brexit, it's entirely possible that somebody will need some kind of working visa in order to work legally and protect both the individual and the business from a risk of an immigration fine or breach. And on the other side of the coin, if you have a non-UK national with some kind of UK visa, whether that's a tier 2 visa or some other type of status, and they leave the UK to return to their home country, remember that their absences overseas may prejudice the status of that UK visa. So you may have invested an inordinate amount of time obtaining the tier 2 visa, only to find that because of home working overseas, the visa is either prejudiced in some way or forfeited. So again, you know, speaking as an immigration practitioner now, because as you know, we do practice immigration, we always advise employees and HR managers to keep a tab on absences, because it's then much easier to understand the position vis-a-vis compliance and any future applications. And finally, from me, a couple of miscellaneous points to mention in brief in the time I have left. So first of all, time zones, you know, speaking on a practical level now, if you've got somebody working in, say, Asia, but your client base is in America and your business is in the UK, will there be a problem in terms of service delivery? Will that be impacted? You know, 2 hours either side might be fine, but there might be a limit as to what you can tolerate. Kits, you know, specialist equipment and the like will become much more difficult to replace or repair if somebody's in Hong Kong or Melbourne or even the continent. Work phone contracts need to be looked at, and similarly with respect to insured benefits, and I'm thinking here about things like Bupa cover and the like. Don't assume that the employee will have the benefit of that cover if they work overseas. Again, it's a contractual question. The terms of the policy will need to be reviewed, but potentially they won't have overseas private health cover under the terms of that policy, so it will need to be checked and potentially reviewed. And finally, but certainly not the least important point, is this question of data protection. Janet mentioned it in the context of the Morrisons case, and data privacy in particular. If data is being transferred out of the UK, personal data or sensitive data, is that permitted? You do at least need to know where the data is going. And with respect to data security, and this is a point really that applies to all home working, not just working from overseas, is the data looked after? To put it bluntly, is it secure? Is it treated confidentially? And if that person is traveling, then is there a risk that data could be lost or seen by third parties? So again, points which can be covered neatly in a home working / working from overseas policy. And that's exactly the type of thing we've been helping our clients with. But quite a lot to think about, hopefully enough for you to go away and have a look at what you have already and plug any gaps. That was all from me before handing over.
Thank you, Anna. It's actually interesting to see so many sort of hidden implications of people working from abroad. I think certainly at the beginning of the pandemic, people thought, oh, it doesn't really matter where people are, let them work from where they are. But actually, as that's gone on, it's become more and more of an issue. So it's really interesting the different sort of strands to that. And I know we've had a couple of questions, so at the end we'll come back to those. But thank you for that, Anna. I'm going to now hand over to Elena, who's going to talk about IR35. Elena.
Thank you, Devan. Thank you, Anna. And good morning, everyone. So I'm going to be covering IR35 and the reforms that are being introduced on the 6th of April, which is really no time at all. So we've got some prep to do in order to be compliant and to ensure that your position is protected. So as you all know, traditionally, businesses in the private sector have been able to engage contractors using personal services companies or other intermediaries without having to give too much thought to the contractor's status for tax purposes. This will change for large and medium-sized private sector businesses under the proposed IR35 reforms. The reforms will switch the responsibility for determining a contractor's status and, if appropriate, operating PAYE and national insurance contributions from the personal services company to the end user business. So what is IR35? As you all know, IR35 is a tax avoidance rule designed to combat what we refer to as disguised employment, and that's in situations where an individual contractor is providing their personal services to an end user via their own intermediary, such as a PSC or a partnership. IR35 applies when the contractor would be an employee for tax purposes if they were hired directly by the end user. If IR35 applies, PAYE and NICs must be operated in respect of the fees paid to the personal services company. So under the current IR35 rules, the contractor is responsible for assessing whether IR35 applies, and if so, operating PAYE and NICs on the fees the PSC receives less certain statutory deductions. So how is IR35 changing? Under the reforms, responsibility for assessing whether IR35 applies moves from the contractor or his or her PSC to the end user. And of course, the end user is you, the company. If the end user determines that IR35 applies, the responsibility for operating PAYE and NICs will move from the PSC to you, the end user. And these reforms will apply to any payments made on or after the 6th of April this year, unless all the contractor's labour was provided before that date. So the end user is required to assess whether the contractor is employed or self-employed for tax purposes. The end user needs to take reasonable care in making that assessment and confirm its assessment together with the reasons for it in a status determination statement, which we call the SDS. The end user must provide the SDS to the contractor before making the first payment to them. So you can see there's quite a lot of work to do before the 6th of April, particularly if you have multiple contractors. They all need a bespoke SDS. So if the assessment concludes that the contractor is out of scope of IR35, the PSC can simply continue to be paid gross. If, however, the contractor is assessed as within IR35, the fee payer is responsible for operating PAYE and deducting NICs on the fees it pays to the PSC, and the end user must also pay employers' NICs as well. In addition to this, a further obligation on the end user is to have a dispute resolution procedure to enable the contractor to challenge the assessment. So let's take a look at what happens when we have agencies in place. If there is a UK agency in the chain which supplies the contractor via a personal services company, the agency is deemed to be the fee payer, and that is because it is the party that contracts with the PSC. As the fee payer, the agency has the obligation to operate PAYE and NICs and pay the employer NICs. But the end user is still not wholly off the hook there. It is still responsible for issuing an SDS and providing a dispute resolution procedure. So who is this going to apply to? Subject to anti-avoidance provisions, small private sector end users will be exempt from the new rules. A corporate end user, which is not part of a group, will be treated as small in its first financial year, and as the guidance tells us, it will remain small until it ceases to be so. So small companies will become medium or large if they meet at least 2 of the following conditions for 2 consecutive financial years. That is annual turnover of more than 10.2 million, balance sheet of more than 5.1 million, or more than 50 employees. So, status determination. What factors do we actually need to take into account? You will all be familiar with both of these, with all of these, but just a quick recap. You would want to be looking at control and working conditions. How much control do you actually have over the contractor's hours and place of work? Can you direct how the work is done, or is it highly skilled and specialised and for the contractor to organise? Do you have a substitution clause? Can the contractor send a substitute? Have they in reality ever done that? And can you, the end user, reject that substitute? Mutuality of obligation. Is there a binding commitment on the contractor or end user to provide or offer work? How are your contractors integrated into the business? How involved are they in management, if at all? How would they introduce themselves to customers as working for themselves or the end user? Does the contractor take any significant financial risk? And do they have to make significant investments into equipment or tools? And other factors to look into. Does the end user impose restrictions on what other work the contractor can do? Does the contract take up the majority of the contractor's time? And have they previously worked or been employed by the company? Now, HMRC has very usefully provided a check employment status for tax online tool that is designed to assess whether a contractor would be an employee for tax purposes if they were hired directly. Now, as you can anticipate, the online tool is incredibly unpopular with end users, generally because the decision after inputting the information is that IR35 applies. Despite that, the tool is useful. It does show you what HMRC is looking for and what it is concerned about when considering status for tax purposes. Just a couple of points to note on that online tool. When you put in your details, it is anonymous, which is helpful. And also just to note that the online assessment, if it is carried out by the contractor personally, that is not binding on HMRC. So that wraps up a very quick update on IR35. And of course, if you need any assistance with getting things in shape or checking the status of your contractors or drafting the status determination statement, then you know who to reach out to.
Thank you, Elena. And I think this has obviously come back to the fore again because it was all geared up for last year, and then COVID hit and everyone sort of put it on the back burner. But certainly it's something that's back on people's radars, and the people who hadn't dealt with it a year ago will be dealing with it now. So thank you for that. I'm just going to, before I move on to Elliott, who's going to talk about immigration, just a reminder that there is that Q&A tab. So if people have got questions, please do put your questions in there, and we'll address them at the end. I'm now going to hand over to Elliott, who's going to give us a whistle-stop tour of the post-Brexit immigration system. Elliott.
Thank you, Devan. And we're going to start with another poll question, which is going to ask if you have experienced a downturn in the recruitment of EEA nationals from on the continent post-Brexit, which is certainly a very interesting question. I think that our immigration practice has pondered quite extensively since the introduction of the new immigration system. I'll certainly be interested to see what the results are in that respect. Okay, some interesting results there, which is more or less a 60-40 split that perhaps we anticipated. So the backdrop for that question and for today's talk is the end of the Brexit transition period, and with it the introduction on the 1st of December, and then for EEA nationals on the 1st of January, the new skilled worker immigration system, which replaces the previous Tier 2 framework and provides for all employees who are recruited from outside the UK, with the notable exception of Irish nationals. Under this new position, anyone who is recruited from outside the UK, either on or before, either from the 1st of December or from the 1st of January, will need a skilled worker visa. But for the people who are currently in the UK, so for EEA nationals who were resident up to the end of December 2020, they still have the option of applying under the EU settlement scheme, and the way that they do so will depend very much on their individual circumstances. So those who have been resident in the UK for 5 years or longer and are able to document that 5 years can apply for settled status. Those who haven't yet reached the 5 years but are planning on staying in the UK on a more permanent basis can apply for pre-settled status, and that gives them a 5-year temporary visa, which then leads through to settled status. Now, they don't need to do anything immediately, but they do have to get their applications in no later than the 30th of June 2021 if they want to stay in the UK beyond that date. And certainly, I think from a planning perspective, it's worth putting in motion steps to get those applications in sooner rather than later, to avoid delays and to avoid issues where, perhaps you get to the end of the period and at that point people haven't got their status and there's then a question mark over their employment. So to profile the new immigration system and this idea of the skilled worker regime. So for the first time in decades, both EEA and non-EEA nationals will receive equal treatment from an immigration standpoint. And that means that EEA nationals will now need employment visas in order to work in the UK. The offshoot of that is that employers who want to employ anyone from outside the UK will need a sponsorship license and will need to go through a visa process to recruit any of those individuals and bring them into the UK, which is much the same as it was under Tier 2. And those who worked under the Tier 2 general regime will broadly be familiar with how the skilled worker route operates in practice, albeit there are a number of changes, which I'm going to run through here in quite a high level, just to profile what we're dealing with. So in order to qualify for a skilled worker visa, any individual who you're looking to recruit must have a job offer from a registered sponsor. And it's worth noting in that regard that existing Tier 2 license holders will have had their license automatically converted to a skilled worker license on the 1st of December. There's no need to do anything else, and there's no admin or paperwork required to make that change. The individuals themselves have to be employed in an A-level occupation or above. They have to be paid at the appropriate rate for the job, and that in itself is a bit of a movable feast in that different thresholds apply depending on the individual's job and their circumstances. They, much the same as tier 2, they have to have sufficient English language skill, which they can prove it in a number of different ways by either taking an approved test or having a UK, an English talk degree. And from a procedural perspective, much the same as tier 2, they have to be assigned a certificate of sponsorship, which is an online database record. They have to go through and submit their visa application online. And then what happens after that depends really on their nationality. So EEA nationals will continue to do what they did before, that they'll go off and attend a visa appointment and enroll their biometrics, whereas EEA nationals have a bespoke government ID app, which is similar to the EU settlement scheme app for those who have seen that, and they don't need to attend visa appointments. And actually, I think just in general, the process for EEA nationals seems to work a little bit faster because of that. So certainly I've seen amongst our client base, EEA national applications probably are processed around 50% faster than non-EEA ones. So in practice, it's a mixed bag of benefits and hindrances for employers, and the skill level and salary concessions are certainly helpful in that you can recruit for more junior roles, whereas previously under tier 2 with non-EEA nationals, it was generally mid-level positions through to sort of managerial positions that were covered by that particular route. There's no longer requirements to advertise before recruiting people, which is a massive benefit where previously you had to put adverts out for a month. You no longer have to do that, and you can make a job offer immediately. The government has suspended the annual migration cap, which means that there's no longer a requirement to put in a restricted certificate of sponsorship request on a monthly basis, which accelerates the processing of the visas considerably. There's more scope for people who are resident in the UK to switch into the skilled worker route. Previously, only limited types of visa holder could switch into tier 2. Under this new route, if you have, say, a tier 5 youth mobility scheme visa, you can switch inside the UK rather than having to leave the UK, which is what you had to do previously, which could throw in a couple of months delay to the recruitment of someone in that position. Further, the abolition of the 12-month calling off period means that you have greater flexibility when recruiting people who have previously held a UK visa. And in a big benefit, those who perhaps have had overseas secondments or have clocked up a significant number of absences and wouldn't qualify for indefinite leave to remain after 5 years, no longer have to either apply for ILR or leave the UK at that point. They can continue to work in the UK under a skilled worker visa indefinitely if they don't qualify, which is a real significant change in policy. So what that means in practice is that, again, it's a bit of a trade-off. So I think there's certainly higher cost involved when you're recruiting any non-UK nationals, and you're probably looking at several £1,000s to bring someone into the UK. Obviously, that's a big break from being able to benefit from the free movement provisions for EEA nationals, where you had the benefit of being able to bring people in and pay only relocation costs, for example. Now you have visa fees and numerous other Home Office costs, which can rack up significantly, particularly where there are family members involved. Also, there are longer lead-in times for the recruitment of EEA nationals, and there is a significant amount of planning involved, even to bring people in as business visitors now, whereas previously, obviously, there was a lot more flexibility there under the free movement provisions. On the flip side, non-EEA nationals have actually come out of this slightly better, in that the concessions that have been introduced allow for the faster recruitment of those individuals. And I think, whereas previously non-EEA nationals maybe had to go through two or 2 to 4 months of the visa process, it's now been considerably accelerated, and perhaps that will avoid people getting cold feet and dropping out of the process, which is certainly something that our client base has seen quite a lot of, where they had to advertise a position and then go through, the monthly immigration cap and so on before even getting to the visa stage. It also allows for the recruitment of a wider variety of roles across the business with fewer salary restrictions and thankfully a lot less admin. And I think the removal of the resident labour market test is something which is, I'm sure, will welcomed by many. So to summarize the position, it is really a trade-off. And I think although you're facing perhaps slightly slower recruitment of EEA nationals, and there are now government fees and skill and salary thresholds that didn't previously apply, we have to see the benefits in how that has affected non-EEA national recruitment, and the fact that there is more flexibility in the rules and a bit more of a streamlined process that just makes things a little less complex for those who are applying for a skilled worker visa. I think the takeaway for me is that it's vital to plan ahead where you can, and to factor those changes into the recruitment of individuals from outside the UK. Ideally, you want to start the visa process a couple of months earlier as a minimum. And I think when putting together recruitment cycles and planning to transfer people, it's vital to get the process moving really as soon as you can. So that's been a very quick whistle-stop tour through the immigration system. And I'll now hand back to Devan to take it away with the Q&A. Thank you.
Thank you, Elliott. And yeah, I mean, there's quite a lot of things have been thrown up by the changes to the immigration system, and of course, EEA nationals also need to think about when they come into the UK as visitors. And you know, previously they could come freely, but now they're treated like any other national, so they can come in for business meetings and seminars and things such as that. But if they're coming in regularly with lots of trips or trying to work here, that could have implications for European nationals in the same way that it would for US nationals or nationals from any other country, actually. So we're just going to go into the Q&A section. I am conscious that the hour is almost up. So I appreciate that some of you may need to drop off, but we're happy to stay on for a few more minutes to answer some of the questions that we've had. So those of you who need to drop off, of course, feel free to do so. Those who've got the time to stay on for a few minutes to address some of these questions, please feel free to stay on. And for those of you who are dropping off, just to let you know, you'll receive a short follow-up email with a short survey, and your feedback's very important, so I'd be grateful if you could complete that. And if you dialed in and weren't able to identify yourself, then you can email events@wfw.com so we know you attended, etc. So moving on then to the questions. So the first question is directed at Anna. So it's about the working from home overseas, and it says, our policy is to permit employees to work 3 weeks overseas per calendar year. Is this potentially opening ourselves up to issues?
3 weeks, okay. I mean, we have to be careful about generalising, of course, but I would have thought that 3 weeks, because it's short, is not likely to give rise to additional employment law protections or issues with respect to tax. Where I can see it being a problem potentially is in relation to immigration again, just thinking back to what you said, Dev, about business visitors in the UK. If we compare it with the UK position, it's not so much about the length of time, it's about the type of work the individual's doing. So applying the UK position, it's possible that a full visa might be required for a period of 3 weeks if the person's rolling up their sleeves and engaging in full work, as opposed to just attending meetings. So I think the short answer is 3 weeks is not likely to be an issue. The immigration position should be checked, but naturally the answer will depend on the jurisdiction concerned. So it's quite difficult to be specific, but you know, as a general rule of thumb, the longer the period of time, the greater the risks. And the problem we have now is that we're entering into year 2 for many people, and that I'm sure does create additional employment rights and the like.
Thanks, Anna. And you were talking about the time outside the UK, so I think one of the other questions is quite, you know, well, is related to that. Is that spending time abroad, working abroad, how could that impact a visa holder with their ability to obtain ILR or naturalisation?
Yes, it's a good question, because in order to obtain ILR, which is indefinite leave to remain for those who don't know, or settled status, it's necessary to not have too many absences from the UK. So yes, it could impact on that. It could also impact on British citizenship. If the number of absences is excessive, that might prevent somebody from naturalising. And the other point to mention is that even if somebody has indefinite leave to remain already, it's a bit of a misnomer because it suggests it's permanent, but actually it can be forfeited. If somebody leaves for a period of 2 years or more in one stretch, then that status will be lost. So a good question to ask, because yes, in respect of those longer term, more permanent types of status, absences overseas can mean they're not possible. Does that help?
Yeah, thank you, Anna. Thanks. And Elena, there's a question for you. So on the IR35 side, so if a client is a large business and a contractor's contract extends past April 2021, and it's already been assessed by an accountant as outside IR35, can the client rely on this, or does it need to be reassessed?
Definitely reassessed. You want your paper trail to be perfect. So I would, it might be useful background. It's nice that some assessment has taken place, but definitely a reassessment and a paper trail of that reassessment. Yeah.
Thank you, Elena. And we've got a question for Elliott. So could you please clarify the difference for those applying from within and outside the UK now the 31st of December deadline has passed in relation to applications for pre-settled stroke settled status?
Yeah, I mean, so for those kind of applications, it's worth clarifying firstly that you can apply under the EU settlement scheme while you're outside the UK. And some of the government guidance is a little bit fuzzy on exactly how you do that. What's worth noting is that there are two key things to my mind. So firstly, it is an important distinction to make on the application form. So if you have someone who was in the UK and they have now left temporarily, for example, and they need to apply for either pre or settled status to get back into the UK, if they're applying while they're overseas, they firstly will need to make sure that they disclose that on the form. And the way they do that is by making a subtle selection in the form to say that they are overseas at the moment. If they say that they're in the UK, it goes off into a different work stream, and it can cause complications if that doesn't then tally up with the evidence that you submit. So I think clarity in terms of the completion of the application form is important, but moreover, you need to then demonstrate the UK residence prior to the 31st of December. So you could do that through bank statements, utility bills, and that sort of thing addressed to the applicant in the UK, and that doesn't change whether they apply in the UK or otherwise. So the documentation broadly remains the same regardless of where you apply. The key change is in specifying that you're applying from overseas. I think if in doubt, it's probably useful to put some sort of explanatory note up with the application, because you can upload any documents that you like. And certainly I've done it with a couple of clients where there have been perhaps some slightly more convoluted circumstances, and we've just wanted to make it clear that they were resident in the UK before a certain date for a certain period, and we've just put in, if not a cover letter, then just a brief explanatory note typed up and turned into PDF form and then uploaded, and I think that would suffice. Hopefully that answers the question, but if there are any other concerns, then just let me know. I'm happy to answer.
Thank you, Elliott. And we've gone quite a bit over the time now, so I think we're going to have to end it there on the questions. But there are a few that we haven't addressed, and if you've identified yourself in the question, we know who you are. We've got your details. So what we'll do is we can follow up with you directly afterwards. So there's one or two where people haven't mentioned their name. So if you want to repeat the question with your name, we can make sure we get back to you on that, within the next few days. I'd just like to say thank you to everyone for attending today, and I hope you found the issues interesting and it helped with the questions that you had and on these topics. Thanks to the speakers, of course, as well for the interesting presentations today on those topics. As I mentioned, you'll get a feedback survey, and we'd be grateful if you could complete that. You know, if you've got any other questions on any of these topics, feel free to, you know, contact your usual contact at WFW or in the speakers directly, and they'll be happy to answer them. So thank you very much to everyone for your time today. Thank you.